Do you administer or benefit from a trust? Or maybe you are a trustee. Hi, I'm Simon Dippenaar and I'm an attorney. A trust is a legal arrangement to protect assets and ensure they are distributed according to the wishes of the donor, the person who owns the assets. The donor gives another party, known as the trustee, the right to hold title to the assets for the benefit of a third party. Trusts are used for various reasons, often to safeguard property for minor children and just sometimes to mitigate inheritance tax liability. There is usually more than one trustee to ensure accountability. But what happens when a trustee does not perform their duties adequately? Can you remove a trustee from a trust in South African law? Yes, you can. The removal of a trustee from a trust is a legal remedy designed to protect the proper administration of the trust and the interests of its beneficiaries. In South Africa, this process is primarily governed by the Trust Property Control Act, which empowers the High Court to remove a trustee if it's in the interests of the trust and its beneficiaries. The removal of a trustee is designed to be protective. The court's main concern is the efficient, honest, and impartial administration of the trust. A trustee can be removed for various reasons, such as incapacity, dishonesty, breach of fiduciary duty, conflict of interest, or even where there is interpersonal conflict between trustees if that makes the trust unmanageable. For example, in the case Land and Agricultural Bank of South Africa versus Parker and others from 2005, the court reaffirmed the fiduciary nature of trusteeship. Trustees must act independently, honestly, and in the interests of beneficiaries. The court emphasized the domination of one trustee by another compromises the independence required for proper administration. Similarly, in Gowar versus Gowar from 2016, the Supreme Court of Appeal confirmed that even where no misconduct has been proven, removal may be justified where the relationship between co-trustees has broken down and the trust's administration has been impeded. The test is not whether the trustee has acted unlawfully, but whether their continued presence is detrimental to the trust's functioning. Trust deeds may contain provisions for removal, but overarching authority rests with the courts under the Trust Property Control Act. The Master of the High Court, who supervises the appointment of trustees, cannot remove a trustee unless permitted by the trust deed. Removal, thus, usually requires a formal court application supported by substantial evidence. Practically, trustees must understand that actions such as failure to keep proper records, neglecting to act jointly where required, or failing to consult beneficiaries can all create grounds for removal. Courts will also consider whether other remedies such as mediation or administrative correction have been explored. Ultimately, the purpose of removal is to uphold the trust's objectives and protect the beneficiaries from potential harm. It is a remedy of last resort, used only where the integrity or proper administration of the trust is clearly at risk. As such, it is both a legal and pragmatic safeguard for South Africa's robust system of trust law. If you are setting up a trust, choose your trustees wisely. They have a legal and a moral duty of care to the beneficiaries of the trust and to the donor. If you are a trustee, I don't need to remind you to act with integrity at all times. If you have any concerns about any existing trust or are considering setting one up, give me a call on the number below. I can draft the trust deed and register the trust. If you're concerned about the conduct of a trustee, I will assess the situation and determine if removing them is appropriate.